Okay, welcome back to Konting Kaalaman, Malaking Katulungan, and we have here our guest, Attorney Diane Grenier. We left off at grounds for divorce, and you mentioned three. One, separated for a year. Second, cruelty and adultery. Now, I wanted to ask you about cruelty. Can you just say something about that?
Well, cruelty is the Divorce Act has been around since a long time, and it was amended in '68 to add the separate and apart. So cruelty and adultery predate that. And now really we look at it and we speak of it as domestic violence. So domestic violence would be the overall umbrella that would include cruelty. So it would be any of those. Of course, physical violence would be the obvious ones. And physical violence can be what sometimes people will say to me, because I give advice on the phone, and they'll say, oh, well, he just pushed me, or she just pushed me, and it was nothing. And but generally speaking, that is not nothing. Mm-hmm. There are situations, certainly, but they're probably not going to be seeking legal advice if it was really just something one-off that occurred in the relationship. So I would say that any sort of physical issues that arise, even if it's blocking the door, preventing you from leaving, as well as harming you or threatening to harm you, threatening to punch you, creating that fear. So there is the fear, which would be, psychological or emotional abuse. And though I'm not familiar, I didn't for this seminar look up some of the recent cases, whether judges would permit the divorce based on cruelty, based on emotional or psychological abuse, but it is likely, and I would not be surprised if there are cases like that, because that does constitute cruel treatment of your partner. So that's generally what it is, but it's not often used, as I say, for the purposes of getting a divorce. It certainly is part of the overall family law case if that is issues that are in that relationship.
And in relation to that, so the domestic assault is tied in with family law, right? Now we call it anything that has, just so the audience know, or the viewers know this, that when you say domestic, it means there's a relationship between the two people that are involved in whatever issue it is. They can be married or not, as long as there is that romantic relationship between them. And even if it's an ex too, right? Even if they're no longer together, it's still considered domestic. So Diane said to us that, you have to prove, apart from of course, you have to prove all of the things that you allege anyway in court, right? Even the fact that you were separated for a year. Well, especially for cruelty and adultery. Now, adultery is harder to prove, like Diane said, because you really have to have evidence that he was doing it. But with cruelty, it's easier to find evidence, right? If you have like bruises, whatever. And if you go to court and clearly he got convicted of, or she got convicted of domestic assault, that alone you can bring to the family court and say, hey, look, right? So I guess the difference then in when it comes to choosing which avenue to take, if you have been abused physically, you need to get out of there as fast as you can, right? Now, sometimes this is not the same in the Philippines, because in the Philippines, once someone gets charged with an offense, it takes so long for something to happen, right? Not in Canada, right? In Ontario, because I'm thinking, Diane, some people might say, oh, you know what, it's gonna take so long if I use this as a reason to file my divorce as a ground. I have to file this charge, blah, blah, blah. It's gonna take longer. I maybe just wait for the year, because in the Philippines it takes years, right? But in Canada, it's not. you have been
no,
assaulted by your husband or your wife, and it goes both
your
ways,
partner,
actually, yeah, or your partner,
that's right.
um,
Yeah,
you can just go to the police, file that case, or complain against your partner. And as soon as they get that, and especially if you have like bruises and stuff, or if you have a witness,
yeah,
that alone, you don't need
yeah.
to wait until they get charged or convicted of
No,
domestic assault, right? You
no,
can take that,
that's
uh,
right.
to family
That's
court and use it as your reason for divorcing your partner, because the
yes. Well,
court.
yes, and you know these things from criminal law. So
Mhm.
that side of it certainly is the situation. I think what I would really like to clear up, though, is to make very clear, is that the difference is that in family law, divorce is not important. And I routinely tell people, forget about a divorce. Divorce only ends your marriage, so you can remarry. If you're not looking to remarry, then there's no rush for the divorce.
Mhm.
So concern about, oh, what grounds of divorce I should pursue is not really the issue. Family law in those situations where there's violence, for instance, or other abuse, is really more focused on getting out,
Mhm.
getting your own place, being safe, getting on with your life, the children, taking care of the children, having the appropriate financial support to do that. Those are the real key issues in family law that are urgent in some cases, but certainly are important, and they're the forerunners of divorce. Divorce really is and should be a bit of an afterthought. Now,
Mhm.
certainly there are some um, um, what am I saying, cultures that, and not just cultures, though I see it more individual views that people have. So sometimes a woman will want to be divorced from the husband because his view of marriage is I own you. And so
Mhm. Oh,
that
yes.
fact that
Ah,
you're married
ha.
is key. So there are situations, but not most are not like that. But when you have that situation, I agree that a divorce does have an important role
Mhm.
early on. And you certainly can start your an application. So court is based on an application. So what type of application is what you determine to be necessary. So you choose
Mhm.
the headings or the issues that you're putting forward. Divorce can be one of them. So you can start an application with divorce and parenting and child support, spousal support, property, everything in one. Or you can start one that does not have the divorce. It has all the other issues. And you get those issues resolved because usually they're far more litigious than the divorce itself. The divorce itself usually falls into place. So that's the key thing, I think, for people to understand. Don't get focused on divorce. Divorce is the end of your marriage, permitting you to get a new marriage license to remarry. So it's really not the main focus. Grant you, the Divorce Act was the act that was amended in March, and the other acts followed suit. So our family law, the other thing I should mention, important, is Divorce Act is a federal legislation. So it is the same in every province and territory in Canada. Family law is individual per province. Each province has their own. It's a provincial legislation. So every province is going to have different rules. They're generally similar, but generally similar is not a legal concept, right? So you do have to be specific to the province that you live in terms of what the family law rules are. The Children's Law Reform Act is a provincial legislation, and that's what we have in Ontario. Other provinces will have other forms of legislation that are focused on the children. And Family Law Act is focused on all of them, and Family Law Act brings in the Children's Law Reform Act. So when you're dealing with children under the Family Law Act, you're really looking at the legislation in the Children's Law Reform Act to deal with those issues. So once the Divorce Act was amended, it was amended to add cruelty.
Mhm.
To add domestic violence to the list of issues that judges are required to review, and it's legislated now. So anyone can easily Google the Divorce Act of Canada and find that section that was added and the exact wording and the detail that's there. And that gives the judge a list, and it's not exhaustive, of things that we would consider. Now, that's important in other issues like children, how much time the children should be, or non-harassment order. Sometimes compensatory spousal support, which is under the Divorce Act. So, and of course, at the very least, it is the background narrative leading to the fact that the parties are in court and have not been able to resolve these issues outside of court by separation agreement. So a lot of times it is difficult or impossible to resolve these issues when you're in a domestic abuse relationship. And, it bears mentioning that when we talk about relationships, we are talking about same sex or heterosexual. And yes, sometimes dating relationships will form part of that, and particularly if a child is born of that relationship. And so living together, actually sharing a residence, is an issue that's more relevant, certainly is more important when you're dealing with support. And we froze again. Are we back?
There you go. No, you're still
sorry.
there.
Yeah, I apologize, but I guess I have this intermittent internet. That's what I'll call it.
Like I said,
intermittent internet,
okay.
and for which I apologize. And I lose track of where I was. But let's deal with the changes. So they added the domestic abuse. So that's now in the Family Law Act as well, the Children's Law Reform Act. And those things relate to the best interests of the child, which is the test that the judge has to apply. Now, what also has changed, very significant, is we spoke of custody and access. And those terms are now gone, and they have been replaced by parenting time and decision making. Those are the big changes that have occurred. Not to minimize the fact that adding domestic abuse to the legislation is very important. Then the other key thing that has changed the landscape is relocation. So we used to call it mobility. So mobility, in terms of a parent who had, in the good old days, custody. So custody meant the child lives full time with you, you made all the decisions. So now that's actually spoken of as parenting time. So your parenting time might be, Friday until Sunday night, every other weekend. So that could be the one parent's parenting time. And then the other parent, which in the old days would have been custody, they have the rest of the time, the child's with them. But then decision-making is a separate issue. So the decision-making can be sole decision-making with that person where the child lives primarily, or it could be shared decision-making. So it's 50-50, even though the child doesn't live with the other parent, except perhaps on weekends. So those are actually broken down, and you can also break down decision-making. So courts will consider whether perhaps one parent should make all the educational decisions and the other parent make all the medical decisions. That sort of thing can also occur. So it's very specific, of course, to everyone's situation. And the domestic abuses issues would fall in there in terms of the shared parenting. It may not, and often is not, possible to do a shared decision making with someone who has been abusive. And you have abuse that is emotional, psychological, that whole power imbalance, and some of it can be very insidious, and sometimes people realize this isn't the best relationship, but they don't go far enough to say, wow, this is not good, this is abusive, this is controlling and manipulative. So there is, of course, sometimes a learning curve there where a person comes to realize that they were not just in a bad marriage. They were in an abusive relationship, which they have to work through. So all of those tie together. Now, relocation, that was mobility. And now what has happened is that there has been a very specific legislation written, or the amendments in the Divorce Act, Family Law Act, deal with the need to give notice. So in March, everything changed, and you can't just move. And of course, you couldn't before, but people did. It was a little more, mysterious, let's say, in terms of can I or not. But now the legislation is that you must give 60 days written notice. So the initial section, 39.1, doesn't speak of 60 days. It says that you need to give written notice. So it's notice in writing. And you have to specify the date upon which this move is likely to occur, and the address and contact information for the child. So I tell people it's sort of like landlord and tenant now. You're given 60 days notice. Folks can relate to that. But it's minimum 60 days notice. That's the cutoff. So you could give 90 days notice, for instance. And if you're moving far enough that it's going to affect the parenting time of the other parent, or another person who has parenting time, because sometimes grandparents end up with orders or agreements for their specific time with the child, then you must also propose how you're going to deal with the changes in that ability. If you move far enough away, alternate weekends is not going to be realistic. Certainly Zoom can pick up some of the slack, a FaceTime, that kind of contact, but also depending on how far you're moving. And of course, that has to be in the best interest of the child. So you give the other party notice or you get their consent. So of course, a parent can consent. And people, certainly people that are not in court are doing that, I'm sure, routinely, where they're agreeing, okay, yes, that's a good move. That's going to be good for the child. And we're going to work out, my time if you move to Ottawa, for instance, from Niagara. Then we'll work that out and figure it out. But where that kind of consensus cannot be reached, then you go to court and you have to establish with the court why it's going to be best for the child to remain in your full-time care and to move to this new place, new location. But absolutely now the legislation is clear that you must give written notice, and of course, or have that person's consent in writing for this move. But again, you still have to provide details, the address, the date.
Well, I have a question.
Those are significant.
So you're talking about, just to make it clear, you're talking about the parent who has so how do you term it now? Because before we say, I am the parent who has custody over my child. How do you say it now? I'm the one who has
parenting time. That's
parenting.
the terminology now, yeah. And decision making.
That's longer. Anyway, okay, so I am the one who has
it's interesting.
Full-time parenting time and decision making.
Right.
Anyway, so question is, so when you talk about mobility, when you talk about, okay, it's no longer mobility, what do you call it now?
It's called relocation.
Relocation. Oh my gosh. Okay. So when it comes to relocation, the rule with respect to the 60 days, the 60-day rule for relocation is on the parent with the full-time parenting time, right?
Yes.
What if it's the other parent who wants to move away? Escape this.
Well, thank you for asking that question, because the legislation covers that too.
Oh, perfect.
If you have parenting time and you're like the access parent in the good old days, you didn't have to give notice. You could move willy-nilly. And that was problematic because sometimes they were moving to avoid child support.
Exactly.
Sometimes, I mean, I don't want to disparage anyone, but that would occur.
Mm-hmm.
So now there is an obligation, a real obligation, and the section is very similar. That refers to giving written notice, 60 days minimum, 60 days in advance, with a address and a proposed date, of course, of that move. So now they are treating both parents or even non-parents who have a parenting time equally. Whereas it used to be it was only imposed on the person who had the child in their full-time care, that they sort of, in a way, could not move, right? They need either the consent or they need a court order to do that.
Well,
so that is leveling it off, and I think fair, because we've seen many situations.
yeah, but is it really leveling it off? I mean, let's take, I'll give a hypothetical situation, right? A woman has a full-time parenting time with the child, and the husband moves to the United States, gave you 60 days notice, right? Moved to the United States,
Yeah,
goodbye, no more parenting time. So what happens now? Like, that's
yeah.
really leveling it off, isn't it?
Well, it is, in the sense that now they have an obligation to give the notice. It used to be that sometimes the full-time parent didn't even know that the father or the other parent had left,
Oh,
right? They
yeah.
just said, well, he didn't call. He didn't call for visits. He hasn't come around. He hasn't picked up the children. I'm not too sure. He's not answering his text and voicemail. Or he said he would, but he didn't mention that he'd moved to the United States.
Yeah.
So
that's
that
the problem, because now the child is the one who will suffer, because once the other parent is gone, and you really cannot force them to call, text, send whatever, anything. They might not even, and I know when it comes to the Family Responsibility Office, they can only really do so much about the support that they're gonna give the child, right? There's so much I guess paperwork and so many things you need to do in order to get money from the person who moved to the United States, right? And what more if they move to
okay, so
continent?
what if we're going to deal with, so when you get into the support side of it, I agree. However, that move, that new address, you can give to FRO, then they can pass along the collections to that state, because every state, except for Texas and Quebec, are on a reciprocal enforcement.
Quebec won't?
Quebec, yeah.
What?
Quebec and Texas
Canada
don't. They don't. You need a Quebec order.
Oh no.
You have to go to Quebec and get an order.
Now they know people
there.
move to Quebec.
And then they enforce their own orders. And of course, you can get that order, but those are the two places. But everywhere else, you would let FRO know. FRO would pass that along to that state or province, and then collections would begin in that state or province. So having the address, having that notice is, a huge improvement, and very, very important to the ability to continue the collection of support, if that's the issue.
I think because
of course,
in California, I think, I'm not sure, but way back, from what I understood from FRO, if your spouse moved or ex-spouse moved to California, and they will just send, I guess, the government of California, whatever they need to send, let them know that they need to garnish and whatever, right? And if they don't do that, the spouse who left, they can even revoke your driver's license here in California, right? So that's you're right. It's a good improvement from before. True.
There's a lot of, now back to the child though, which is the real key and important subject here. Yes, the child is going to be impacted, because now that parent's not here, that parent may be far away, like California, and but what I tell, unfortunately, the only advice I can give to anyone is that you cannot force another person to be a good parent. So they could live down the street and not want to parent and show up for their weekends. They don't have to move to California to do that, to impact negatively on the children. And then that becomes a whole different issue, because now Of course, it does become complicated because sometimes people fall out of their children's lives on purpose. Now, there's always two sides to a story, but those that choose to, just absent themselves or move elsewhere may, after a few years, decide to come back, may, after a few years, decide they want to be involved again. And now the parent who has had the children full time will be looking to figure out, well, why should I let this person back in? Because look how devastating it was to the children the first time they disappeared. And how can we be sure this isn't going to happen again? So it becomes now a question of, and usually in litigation, how are we going to reintegrate that parent? Again, if the parent comes back and seems to be sincere, then one would expect that, that break isn't going to happen again. But there's no guarantees that, and every situation is different. But at least now there's some legislation that deals with putting some onus on that parent that does not have the full-time care, but still, a recognition that they need to also be responsible. They need to tell the full-time parent or the full care parent where they are and maintain contact for the children as well. So those are quite significant changes to our legislation and to the way that we have approached family law. Now, there was a very significant child support case. Now, the child support legislation, on the other hand, has not really changed. And I continue to be astounded and will say to people, well, the child support legislation, the child support guidelines, so the federal child support guideline is a federal legislation and does cover all the provinces for child support. And there's a table and you look at gross income, and that's how the quantum is determined. That legislation was written in 1997. It is not new. And it has always been in the legislation that the parior parent, so that would be the parent who does not have full-time care, would have to provide their income information, is what it's called. Now, we generally say your tax return and your notice of assessment, because that generally shows it, but it's not limited to that. If you have other income coming in from other sources, you are required to provide that. So it's all your income information is what you are supposed to provide every year to the other parent. Nowhere in that legislation did it ever say that the recipient had to ask. And I use the analogy, I mean, I don't know, some people may find it appropriate and some may not, but I use the analogy that the police are not standing in your driveway every time you get in your car and say, oh, would you please put your seatbelt on? So, recipients do not have to stand at the curb and say, please give me your tax return. You need to give that tax return every year. If you have shared parenting, if you have equal, and equal can be 15 days a month in one home and 15 days a month in the other. It could be 1 week, 1 week. It could be 3.5 days, 3.5 days, whatever works out to be equal on a month basis. Some people have a 3-day, 4-day pattern. When you have that, then both parties are obligated under the legislation to exchange tax information. So both parties must give the other one. And it's not, again, a matter of asking. The legislation says do it, just like the seatbelt law. But still today, there is a great misunderstanding. There are other areas of misunderstanding that have been around since 1986. We'll get into those. But for the purposes of support, that's a big one. That's a key one. So everyone needs to know that and keep that in mind so that they can stay within the law in terms of their obligations. Of course, the obligations is pay support as well, but at least give your tax return. Now, along those lines, what was I going to say? So the child support, providing the tax return this year, not this year, sorry, I've lost track. 2021 was also significant because in February of 2021, the Supreme Court of Canada made a landmark decision in Colucci and Colucci. And that is a child support case. And it had been, of course, through the court system for a long time. And it changed the approach of some 15 years, an approach that was being taken primarily in Ontario, but other provinces, where judges were putting a great deal of onus on the recipient and saying, well, you didn't try hard enough, and why don't you have the tax return? Yes, and they also were limiting a recipient's ability to go back only 3 years. We're not going back farther. You didn't come sooner, and putting a great deal of onus on the recipient for not bringing it back to court, to change it, to increase it, to get the tax return, whatever. Colucci, Supreme Court of Canada, said, no, wrong. There's no time limit on how far back you can go. They literally did open the floodgates, which I personally believe was certainly the right thing to do.
Before you
the
go,
floodgates in the sense that you could go back now to the,
go back to
well,
what?
you can go back to the date of birth of the child if that parent did not pay.
Oh.
Or back to the last tax return that you received that would have you would have been able to determine that's the correct amount of child support to be paid, because you need you need income information to be able to set child support. So they did open the floodgates. They said, yes, you may go back now to that date. So child support technically begins with separation, right?
No, that's
so before that.
But is that retroactive? Like, I mean, would that apply to?
Yes. So people refer to it as retroactive. I kind of like referring it to as the date of commencement, because that is the legitimate date that you're supposed to begin to pay child support. So that's either the date of birth, if you do not live together, or it's the date of separation, if you did. And so if now Colucci was a situation where this man, he was the payor, the father, 10 years. He was behind by 10 years, not providing his tax return. And of course, Mrs. Colucci had gone through the court system and undoubtedly I did not read those lower court decisions, but would have, been told, no, you can't go back that far, and why don't you have tax returns and all that sort of thing. And the Supreme Court reversed all that. So he owed $150,000 in what we would call arrears, right?
Oh, let me just, okay,
So,
get my calculator. I need to calculate.
Don't do it.
I'm just kidding.
So now it's time, but you have to understand now, when you're representing the payor, so if you have a payor coming in, it did create, more difficulty, let's say, representing payors who have not provided their tax returns. You have to sit down and be realistic with them, and you have to say, look, you didn't provide your tax return, give them to me, let's calculate it before we do anything. Now, usually they're coming into your office because the other side has started a case against them. That other side has commenced something, they're in court, and they're being told that they owe, this sort of monumental amount of money back. So now the best you can do is say, look, let's negotiate in good faith. All you can do is make the best offer you can to pay, and perhaps the other side will accept less than the total that's owing based on your income. Most of the time, those applications are started, or motions to change rather, are started by the recipient without income information. So they are guessing, or they are simply saying, I don't know what he earns, and I want all those tax returns, and I want that money. So it's very much an unknown quantity for them. But it's important for people to know the legislation, and the obligation, the obligation that you have. Now, if you are sharing expenses, so in the child support, federal child support guideline, or federal child support legislation act, it also provides for sharing expenses called Section 7. And there are,
before we go to Section 7,
and
before we go there, I like the updates. I just want to, okay, I just want to explain it to the Filipino community in Tagalog, just so it's very clear. But before I do that, I just want to make things clear too, right? Because I'm not a family lawyer. That's why I'm just getting, this information from my friend here who is a family lawyer. So Diane, just to make it clear, if a person who has never filed any case for support against her spouse, right? Now she can?
Yes.
So she can go back?
And
Okay,
she should.
so I'm just gonna speak in Tagalog if you don't mind. I'm sorry. Okay, so dun po sa mga
That's
nakikinig,
fine.
gusto ko pong linawin yung sinabi ni Attorney Diane Granier. So kung meron po kayong anak, for example, meron po kayong anak at hindi po kayo binibigyan ng suporta ng magulang, ng tatay, or kung sino man ang dapat magsuporta sa inyo. Let's say yung tatay ng anak ninyo. At never po kayo nag-file ng kaso sa korte para humingi ng support sa kanya, pwede nyo na pong gawin yun ngayon kahit hindi nyo po ginawa before. At ang sinasabi po ni Diane, meron pong lumabas. At ito po sa Ontario po ito, Ontario Courts. Oh wait, no, Supreme Court, sorry. Supreme Court. So the Supreme Court came out with a decision on Kaluchi versus Kaluchi. Kaso po yon tungkol sa family law at specifically tungkol sa support. At sinabi ng Supreme Court na kung meron pong dapat bayaran sa inyong support, simula nang maghiwalay kayo, kung sakaling kasal kayo or nagsasama kayo, or simula nung pinanganak ang anak ninyo, kung simula pinanganak ang anak ninyo, hindi na kayo binigyan ng suporta ng magulang ng anak ninyo na dapat magbigay ng support, pwede na po kayong mag-file ngayon ng suporta laban dun sa tao na yon. So, naulit ko po, pwede nyo na pong gawin yon. So, pwede nyo pong, ang pinakamaganda nito, kung yung sitwasyon na yon ay, kayo po ay nasa ganung sitwasyon, ibig sabihin. So, ang payo ko po sa inyo, pumunta na po kayo sa, I guess, tumawag kayo sa legal aid, magtanong kayo ano dapat nyong gawin. Kasi sila po yung makakatulong sa inyo na hindi kayo magbabayad. Or, kung gusto nyo naman, pumunta po kayo sa isang family lawyer para magtanong tungkol dito. Sabihin nyo po, banggitin nyo na lang po yung kaso na yung Kaluchi versus Kaluchi. Sabihin mo, gusto ko pong malaman kung pwede kong gawin ito. Sabi sa akin, pwede ko daw pong gawin. Baka pwede nyo explain. So, hindi po ito para sa lahat. Siyempre, kailangan pasok po kayo doon sa sinasabi ng Supreme Court na sa kaso ng Supreme Court na yon. So, kaya ang pinakamaganda nito, sabihin niyo po, pumunta po kayo sa legal aid, pwede kayong tumawag sa duty counsel, or sa family lawyer. Itanungin niyo po kung anong karapatan niyo bilang magulang ng anak. Kahit matanda na yung anak niyo, sinasabi ko, kung ang anak nyo hindi binigyan ng suporta, simulat sa poll, pwede nyo pong habulin yung tatay or kung sino man dapat magsuporta sa anak nyo. So mag-English na ako ulit. Okay, so I just explained to them that even for those who were never married, right? Who were married, yes, and wanted support from the husband, the spouse, who's supposed to give support to their child, they can now go and file that against that person. But if they don't know it, but just to be clear, okay, and I should have said this earlier, whatever you hear in this program is not legal advice, okay? This is for informational purposes only. We're both lawyers, but we're not giving advice to you. We're just telling you, and Diane is informing us of what the new legislation is, what the case is about, family law that you need to know. So my advice to you is that if you think you fall under, whatever we've discussed here, the best thing for you to do is go to a lawyer and explain your situation to that lawyer, because not every situation is the same, and not every situation will fall under whatever we talk about here. So best advice is go to get a lawyer. And if you do not have a lawyer, and if you do not have the means to get a lawyer, then call Duty Counsel Family Law. And you have a number for us, right?
Yes. Well, I knew you were saying that, and I thought, yeah, we should clear up. So I do work for legal aid, so I am giving legal advice as my job. And legal aid has always had a 1-800 number. It is not new to get legal advice by telephone. And the legal aid number is 1-800-668-8258. You can also go to the legal aid website, and there's lots of good information there. You can understand and follow what legal aid has. There's some question answers, similar to what I've been telling you. It hasn't been updated for the 2021 changes that I'm aware of, but I haven't recently read it. I apologize. But the legal aid website, yeah.
1-800.
1-800-668-8258.
Okay.
And when you call there, that's legal aid. Legal aid provides family law, criminal law, and immigration law information. So advice, rather. So yes, what we're doing now is called public legal education, right? That's what we're doing. When you call and you have a lawyer call you back, because that's the way legal aid operates for you to get advice, that lawyer is giving you advice because they're giving you specifics based on what you tell them your factual situation is. So that's the difference. Right now, this is public legal education, just general. And yes, to get real advice and to determine what to do, that you need to call and get specific advice. Now, that's one place legal aid is for low-income Ontarians, so it is dependent on income. Now, at this time, legal aid has waived the my goodness, my light just became much better. Interesting. Anyway, legal aid has waived the financial criteria since COVID. So we will give legal advice to people that may not qualify financially for other legal aid services. If you qualify financially for other legal aid services, those include document preparation, duty counsel helping you in court, just similar to the criminal court system, but with family court. And of course, that's almost all Zoom now, or by telephone, as I say. And the other thing is a certificate, and a certificate pays a lawyer. You hire the lawyer. Legal aid has a list of lawyers from which you choose. So those are the main services. You can always call back for more advice. If you don't qualify for the others, you can call back and get more legal advice on a as-you-go basis. And the other place you can get one-time only legal advice is from the Law Society. There's a lawyer referral service. So you can call there, and I do have that number. Do you want that number?
Yes, yes.
So, yes, give me a moment here to
This is the lawyer
find it for you.
Right?
Pardon?
This is the lawyer referral service of Law Society of Ontario.
Correct.
So we're talking about
Ontario
only for these ones, right? This is exclusive for Ontario. Yes. Okay.
Correct. Now, most provinces, I would say all provinces, must have a legal aid similar. So Alberta legal aid, British Columbia legal aid. So if you need that advice, then you can find those, I'm sure, online. So the lawyer referral service number is 1-855 947 5255.
Okay, so it's 1-855 947 5255. Well, guess what, Diane? We're at the end of the show. It's an hour, right?
So much more to tell you.
Well, but hey, we're going to continue this in the next episode. So let's tell the audience now that there's still more information that my friend here will be giving us with respect to family law. And I mentioned this earlier when I was introducing you. I know that legal aid also has a certificate for immigration too, right? So maybe we can kind of rush into, like, I guess, mention it a little bit, but in the next episode. So for now, thank you so much, Diane, for all the information you've given us. And it's your opportunity to say hello to your friends, like Mr. Who else? Who do you want to say hello to?
My friend Bill Hewitson,
Yes, Mr. Yu. Yeah.
he was
With
one
him.
of our star duty council, and he has
Yes.
retired and enjoying retirement, and deservedly so. But everyone, I just say hi to all the people I don't know and my future friends. But I thank you so much, and I feel so much better. We hit on the really high points, the important things that I think people need to know going forward.
Mhm.
And I look forward to our next time together.
Yes.
Certainly, hopefully, less than 12 months from
I
now. Like it
know.
took us a year to actually get it together. But
Yes.
we
Yes.
we we now. I have my technology a little better under control, as you can see,
Mhm.
not entirely, but
Yes.
it's better.
No, but actually, your lighting is perfect now. Seriously. But anyway,
It
so
is.
again,
I
thank
have no
you.
idea why though.
Well,
If I could. Oh,
that
it's my
time.
window. I think it's the sun. The lighting has changed.
Yeah.
Oh well, I can't control that.
Diane, thank you so much. And by the way, Diane is a French Canadian. So
Mais
you want
oui.
to say hello in French?
Bonjour mes amis. Et je donne les avis en français aussi. Et il y a des avocats francophones, si vous voulez parler français. So Legal Aid has not just bilingual, so I said French speaking, so I do give French advice. But what's important is for everyone to know that Legal Aid has translation services for all languages. So
Mhm.
when you call Legal Aid, if you are more comfortable in a different language than English, please say so. It's important to be able to speak, more readily with the lawyer, particularly, but even the frontline people when they answer the phone. So know that you can speak languages other than English. We do subscribe to a translation service, and it's very efficient. And I think many people find that they can express themselves better in their own language. And so do that. And yes, we'll talk a little bit. I'll brush up on
Yes.
the immigration because I don't do immigration
I know,
law.
I know, I know, I know. Okay, well, thank you so much.
But
And I just want to greet my friends too. Still in California because I'm trying to escape the winter weather in Canada.
it's
But
cold here.
it is cold. So I just want to say hello
Yes.
to all my friends here in California, Edna Morales. There's so many. Si Odi, Happy New Year. Barb, Oi, si Lenny, Bon, Mitet from San Francisco. We're currently in Pechanga, in the casino hotel in Pechanga right now. So I'd like to say thank you to my niece who treated us out here, Maxine De Luna. I also, of course, oh, by the way, I just want to say hello to my daughter who's here with me right now. And my mom and everyone else there, my aunt who was here, Tita Beth, Ninong Ante, my cousin Brian, his wife Apple. And you know what? I want to say, get well to my son. He currently has COVID. And,
Oh.
I'm really worried because I got so worried yesterday because he could not talk. He didn't have a voice.
Oh.
So he did not know what to
Oh,
do. He had
my.
COVID symptoms. He didn't know he had COVID yet, but he had a fever of 39.2 temperature, and he couldn't go to the doctor because they won't let him, right? But he couldn't call because he couldn't talk. And he didn't know which doctor can do it online. But anyway, some people helped him. Thank you, Michelle Verashon, my ex-sister-in-law. Thank you so much for getting his medicine and dropping it off and dropping off the antigen test. And so that's why he found out that he has COVID. So get well soon, anak. Just keep us updated and just, I'll pray for your speedy recovery. So that's it, folks, for
Prayers for
today.
your son.
And Diane, I'm going to be saying goodbye to the audience, but don't go. Okay, we'll still talk. So
Okay.
again, thank you so
Thank
much, to everyone who listened. Hopefully, I'm sure you learned a lot from our guest, Miss Attorney Diane Grenier. And again, this is Attorney Maria Ellen Rodriguez, ang inyong kaibigan, your source of information and legal counsel who has the Filipino community's best interest at heart. Dito po sa Konting Kaalaman, Malaking Katulungan. Till next episode, don't miss that because you will learn more from Attorney Diane Grenier.